RAs. These are people who were paid money to live in this house. And that was not a commercial activity under the zoning code, because it was a single-family residence that was being used for a single-family residential purpose. People living in the house. The other case that I brought to the Planning and Zoning Commission that I also bring to your attention again today was a Utah Supreme Court case that stood for the very strong proposition that duration is not the test for determining use of a property. And let me give you the example of that. I have a home, and I've been blessed, down in Truman Annex in Key West. I'm going down there on Sunday. I have depositions on Monday and Tuesday, and I'm going to be leaving there on Friday. I'm going to be down there for 4 days, 4.5 days. And I'm going down there for a short purpose, to actually conduct business while I'm down there. And then I'm not going back there again until sometime in January or February, depending on my schedule. And I may go down there for 3 or 4 more days, and my law office will send someone else down there to reside in there when I'm gone so that they can handle some of the work that's going on a short-term basis. And they're going to do it, and my firm rents the house from me because I'm renting it out so the firm can use it while I'm doing these things on a short-term basis. And the answer is that we have 1 parking space at our location. If you have another car there, it gets towed away. We have a noise ordinance. We have a garbage collection ordinance. And we have code enforcement that follows through. Did I do something different than what my clients have done here in the city of Venice, but allowing people to use the property for single-family purposes? Not to use it as a barber shop, not to use it for renting out for a travel agency, not using it for business purposes, but using it for single-family residential area. I would suggest to you that when you go through the record, when you look at the items that we have submitted to you, when you look at the case law that stands for the propositions that clearly support the constitutional rights of property owners, and you look at the way that these cases are, you'll find that these cases and this law shows clearly that Mr. Slaughter was incorrect in his zoning opinion. Now, lastly, let me address the 2 new cases that were cited by Ms. Zellman. One is the City of Treasure Island case involving a doctor who was renting out his house on a room-by-room basis for being part of his drug rehabilitation. Each room got $1,000 a night, and so therefore the people that were renting each room, they had a right to the room and a right to part of the common spaces. That's not this case. Judge Scriven, who is the magistrate in Tampa, ruled, and the court adopted her opinion, and that's a rooming house. I don't have any problem. You can't rent out single family. That becomes a difference instead of using the house for an entire single family purpose. So that is totally a distinguishable case. The other cases that are cited, I think when you look at what we have provided to you tonight, that you cannot come to a conclusion that changes the zoning code of the city of Venice without you legislatively enacting it. And so we ask you to do what the Planning and Zoning Commission did. We also disagree with the standard, by the way, that you give the highest standard to Mr. Slaughter, but ignore the Planning and Zoning Commission, who heard all of the evidence in the case. And we ask you to follow what the Planning and Zoning did, review the CD, this DVD, and the tape of the commission if you have any issues on it at all. And we ask that the transcript be attached as an exhibit, Mr. Anderson, to this proceeding. And Mr. Mayor, if you allow that to happen, I would appreciate it.
Thank you.